The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And good morning. We have three cases that will be submitted. Those cases are State of Iowa versus Clifford McNeal. Second case is Pauline McKee versus Isle of Capri Casinos and IOC Blackhawk County. And the final case is Iowa Supreme Court Attorney Disciplinary Board versus Vicki Ryan. Now the last case will be submitted at this time without an argument, and we'll first hear the arguments in the State versus McNeal case. And after that case, we'll take a break for the tornado drill. I think you've been instructed on what we'll be doing there. And then we'll resume around 10:30 and pick up the McKee versus Capri Casino case. And I also would like to welcome Mr. Zika and the high school government class from Lamar's. Thank you so much for being in our courtroom this morning. I hope you enjoy the arguments, and I understand you're here as a guest of Senator Sodders. So welcome and enjoy. With that, we'll proceed to the first case. Ms. Triick.
May it please the court, counsel. My name's Mary Triick, and I'm here on behalf of the state this morning. This case does not involve an anonymous tip in the traditional sense of the phrase. Rather, this case asks the court to consider the related but fundamentally distinct situation when an officer gains useful information in the course of an investigation from a citizen about publicly observable facts, and then uses those facts in a warrant application without expressly naming the citizen from whom they came. That's what happened here. The unnamed citizen told an officer publicly observable non-criminal facts that anyone in the community could have known. He told the officer that the defendant had possessed this trailer, that he had moved it out of town recently, and that it was now parked at a specific location out of town in the country. That was it. The citizen did not accuse the defendant of any criminal behavior. He did not report that the trailer contained stolen property or anything of that nature.
Let me kind of try and back this up. I mean, am I correct that the only piece of information by the time the warrant application was filed that the tip added was really that the trailer had been recently moved? Because every other piece of information, the information from the person who had been arrested for stealing the property, the current location of the trailer, the fact that it was owned by the defendant, all of that information had other sources. So is that the fact of recent movement, is that necessary to establish probable cause, or would you have probable cause without it?
We certainly have probable cause without it. You're correct that that is the only piece of information, that the sole source is the unnamed citizen by the time the warrant application is finished. And the state believes that piece of information is useful to the warrant application and should be properly considered and is reliable, but it's certainly not necessary for the finding of probable cause.
Let's take Justice Mansfield's hypothetical one step further. What if you struck out all the information from the anonymous tip from the search warrant application? Would there still be probable cause?
Well, if you struck out the piece of information that the trailer was recently moved.
If you struck that out too, you take all inferences from what's there, would you still have enough probable cause without that information?
Well, the state believes there's probable cause without the information sourced to the anonymous tip.
Well, and why do you believe that if you strike out the evidence regarding movement of the trailer? So the evidence would be simply that the trailer was located where it was, and it was owned by the defendant. You had information from Jones regarding the receipt of stolen goods and so forth and so on. But let's assume for purposes here that you don't have any evidence of recent movement.
Yeah.
Is that sufficient? I think the real question is that sufficient nexus, to use our vocabulary, is that sufficient nexus to support a search warrant?
Can I add one fact to that? And it was also known, I think Jones said that the person was going to move the items, didn't say where, when, or how, but it was going to move the items. That's, I think, another important fact.
Well, I think what he said was that they had been moved already, but he didn't say where or exactly when. I think it's important that we consider when establishing nexus that it's not required in our law that we have direct evidence of the nexus, that the courts regularly are and are fully entitled to consider circumstantial evidence. In Groff, the court outlined some kinds of circumstantial evidence that are often used. We can consider the type of the crime, the nature of the item searched for, the defendant's opportunity or non-opportunity to conceal and move those items, and basically just all natural common sense inferences about where someone would store these items. So in this case, we had probable cause to believe the defendant had a large quantity of stolen construction equipment that takes a big space to store. We know from Jones that he intended to keep these tools, that he wasn't a fence, so he would need somewhere to long-term store them. The defendant had not had this property originally delivered to his house. He'd had it delivered to a secondary location owned by his wife. And he had told his accomplice that he had moved it from that location, known to his accomplice, to someplace more secure from police discovery because he knew the police were on to him. This supports an inference that he probably didn't move it back to his house. So at this point, the officers discover this trailer. The trailer is parked out. It's big enough, it's readily movable, it's locked. It's parked out in sort of a nondescript part of the country, well back from the road, making it, without this tip, basically impossible for the police to find. It was on somebody else's land. It was the perfect place to hide this property. And these facts, when taken all together, are sufficient that a reasonably prudent layperson would believe that there's a fair probability that the evidence we're looking for would be discovered in this location.
How visible was it from the road?
The trailer was visible. I think the question is whether the warrant application establishes how visible it was. The warrant application basically just says it was back from the road. At trial, we learn that the license plate was not visible from the road, that it was sort of backed onto the land.
Well, so in terms of the warrant application, it's a fair point. As you know, we're looking at the four corners of the warrant application, and I think you're inviting us to excise, in part, what came from the informant. It doesn't really establish, I guess, that the trailer is secreted on the property. It's back some distance from the road, and that's about all we have, I guess.
It is. I mean, I think that there's plenty of circumstantial evidence once they know that this is the defendant's trailer, it's not parked on his land, it's locked, that this is the perfect place. They knew the defendant was looking for a place just like this.
I don't think you've established it's the perfect place, to be honest with you. I think you have established ownership, and you have established out in the rural someplace, and have established 150 feet back from the road.
Yeah.
Is there more in the four corners of the warrant application other than what I've described? I mean, you characterize it as a perfect place, and you haven't quite got me there yet.
Well, I mean, other than the facts I outlined, I don't think that there are other facts. I think that the important thing is that we can make reasonable, common sense, prudent inferences from those pieces of fact. I, however, don't want to back off from the fact that it's strongly the state's position that the information that the trailer was recently moved was both presumptive reliable and also confirmed by further police investigation. In this,
what would it add to if the warrant application had given the citizen's name? Why does the anonymity a problem when we're not dealing with a paid confidential informant or someone who's trying to trade information for leniency?
well, I don't think the four corners of this application indicate whether or not this citizen affirmatively didn't want to be named. I think that easy to see how an officer might not simply have provided the name. Sergeant Bell certainly knew who this individual was. This wasn't an individual unknown to the police department. It wasn't an individual who sent a letter or who called in and tried to accuse somebody else of a crime without anybody knowing who they are. And so I think the fact that they're an unnamed citizen is not particularly important because their identity isn't particularly important. Most anybody in the community could have seen that this trailer was parked in town for some period of time, and now it's not there. Now it's out of town at this other location.
But in order for the tip to have something more than what the general public would know, don't you need something to the effect, I saw him load the tools in or he moved the tools out? Sort of like when you get to I think it's the JJ case, where with the drugs, the drugs are in there, she took the drugs, she went down the street, she went this way and that way. This doesn't even have any indication the moving the trailer in and of itself was a crime.
Well,
And doesn't have any nexus, this anonymous tip doesn't have any nexus to the crime other than a trailer was moved.
No, it doesn't. It's like the police officer asking, hey, does anybody know where the defendant's recently been staying? We haven't been able to find him at his house. Or does anybody know what kind of car the defendant drives? If the police officers show up at a suspect's house and he's not there, and they ask the person sitting on the porch, hey, do you know where he is? And they say, yeah, he just got a job down at the hardware store. He's down at the hardware store. It's that kind of information. In this case, the police were engaged in an ongoing investigation. They were looking for somewhere the defendant might store goods, and they would have been asking around the community to find out if people knew of places under the defendant's control that he might have stored these goods. There's no indication in this case that the speaker had
A hunch that the goods are in the trailer rather than, speculation. He could have put them in the trunk of his car. He could have put them in a shed. It's just a hunch. It's just as reasonable they could be anywhere else.
I think it's a reasonable common sense inference. I certainly don't think the state had proved beyond a reasonable doubt that the tools were there. But when we're talking about warrant applications, we make all reasonable inferences in support of a granted warrant application. And in this case, we're speaking in probabilities. And the probability here was that the tools, there was a fair probability that those tools were in that trailer.
I'll ask you a question about valuation. My understanding of the record, and I want you to embellish my understanding, but the record shows that the retail value of the tools was something around $16,000 new. And then there was some testimony, I think, about replacement costs of the tools. But what evidence is there? For the crime charge, you need property in excess of $10,000, I think. And basically the law on valuation is you can't have speculation, that lay opinion may be valuable, maybe if it's not based on speculation. There's also some cases out there that say replacement cost is insufficient to establish current value. So help me out on the state's best case that $10,000 of property was involved.
Well, I think you had two pieces of information. So you had the owners of the tools who could identify a number of the tools, so certainly a small percentage of those found in the defendant's possession. And they testified that they had to replace those tools and that they don't buy used tools, that they buy new tools, and the replacement value of those new tools was $16,000. Jones also testified that he sold the defendant somewhere between $30,000 and $50,000 worth of used tools. He's not sure of the exact value, but he believes he received about 10 cents on the dollar and that those tools were worth $30,000 to $50,000. I think those two pieces of information together are sufficient to prove that the defendant possessed more than $10,000 worth of tools. I do want to get back to Justice Wiggins' point briefly about the JL case. The JL case says that you can't take, when an anonymous tip asserts concealed illegality and then provides a bunch of publicly observable information, you can't confirm only the publicly observable information and for that believe the concealed illegality. But in this case, we have three facts. They're all publicly observable, and we confirm two of the three. And so there's no reason that we can't infer that the speaker would know the third publicly observable fact from our confirmation of the other two. Further, the third fact wasn't totally unconfirmed. It was entirely consistent with the other information we had, that the defendant had recently moved.
But in JL, they saw the car moving. No one saw the car moving here.
In JL, I believe JL was the case with the kid with the concealed
Sorry,
weapon.
not JL, Alabama, the other case, the White versus Alabama.
Yes, although, I mean, I think in those cases, the tip both asserts concealed illegality. And here, as you pointed out, as the Court of Appeals pointed out, the tip does not assert concealed illegality. The illegality was asserted by Jones, our named informant. This tip only was one piece of information that helped us establish the nexus. And in a warrant application, as opposed to, say, an anonymous phone call where the officers then stop a car, we have a whole totality of circumstances. This is a long-term, ongoing investigation, and we have to look at the totality of the circumstances and not engage in any sort of overly technical attempts to invalidate the warrant. We have to base our decisions on common sense inferences that are made from that information. I do want to briefly talk about error preservation, although because I'm almost out of time, perhaps I'll save that for rebuttal.
Thank you, Counsel. Mr. Kemp.
Morning, Your Honors. May it please the Court, Counsel. My name is Chris Kemp, and I represent the appellant resistant to this application for further review. The Court of Appeals correctly found that there is not sufficient probable cause to issue a search warrant for Mr. McNeal's trailer. First, the anonymous tip did not provide any assertion of illegality.
Let's assume the anonymous tip is bad. Tell me why there's not probable cause without it.
Well, the anonymous tip is the link to the trailer.
No, because the police go out and confirm the trailer's there, and they get the license plate, and so they now have an independent knowledge. It's the fact that the trailer's there is not based on the anonymous tip anymore after they drive out and see it, and the police now know that the defendant has a trailer in a rural area that's large enough to arguably contain stolen goods. So Justice Wiggins is asking the question, why isn't that enough? You've got Jones saying, I sold stolen goods to this guy. All right, let's go look for him, and there's a reasonable probability that the stolen goods are in this trailer.
Well, I don't think that you have the reasonable probability that they're in the stolen trailer. The search warrant application indicated that Mr. McNeal owned a construction company. He owned an auto dealership. He had at least 2 properties that were mentioned in the search warrant. So there's something about that anonymous tip that specifically points to this trailer.
But couldn't the police get a search warrant for the different places that your client may have stored goods, whether it be the auto body shop, whether it be his home, whether it be the trunk of his car, whether it be the trailer? I mean, based upon the information it had that the tools were sold to him, they were going to be moved, and he was going to keep them. I mean, wouldn't that be enough to get a search warrant for all those places?
I don't think so, and a big part of that is because all the source of this information is coming from Jones, who was the person who actually stole all the property. He got a deal, a cooperation agreement. He was looking at a 25-year sentence on ongoing criminal conduct, and he just pointed the finger completely at McNeal. You have to look at his credibility. He was the other person who was committing the thieves.
But most confidential informants are in the same situation, and we say you don't even have to say the name for those people, and if they gave reliable information, it's good. So I don't know how we could discount it just because he wasn't pristine.
Well, I don't think we have any indication of reliability from him, whether he's worked with the police before, or he is a named informant in that part. He did give some specific facts, but they're certainly against his penal interest. Without the anonymous tip, none of his information is corroborated at all.
Counsel, I want to just go back for a moment to this nexus question. And following up on Justice Wiggins' question, do you concede that the state could have gotten a warrant for his business premises and perhaps his house and garage?
I think the state probably could have gotten a search warrant for the second location. I believe it was under his wife's name, since that's where the defendant or the person who was stealing said that he sold the property to him.
And that's based upon your analysis, your common sense analysis of where would the likely places be for storing this kind of stolen equipment, right?
I think it's from Jones's testimony that here's where we actually sold the property.
Okay, but also isn't part of the analysis, where would a person who's receiving stolen property likely keep it, correct?
Sure.
And so I guess what I'm struggling with is why would it be less likely that he would keep it in the trailer than at any of these other locations that might, from a common sense standpoint, be places you would look?
I think a really important distinction is that in the search warrant, Officer Harris is the affiant, and he wrote, "Sergeant Bell told me he received an anonymous tip from a concerned citizen that Mr. McNeal had moved a trailer." In the summation for why the Officer Harris thought that he had probable cause, that's when he added the conclusion that the trailer was recently moved. So if we take that temporal modifier out of the conclusion that Officer Harris made that wasn't supported by the anonymous tip, all we have is that a trailer is out on some other property that Mr. McNeal owns. I think that's important, and nothing in the warrant indicates that the state indicated that in a normal police investigation they're asking questions of citizens. Nothing in the search warrant indicates that any of this information was discovered in an investigation.
Would this stolen property fit in the trunk of a car, or would it take something larger like this trailer to contain it?
The testimony at trial was these were reciprocating saws, drills, a lot of hand tools and construction equipment. We're not talking about large objects that you need a flatbed truck to move or hide. The aggregation of the value was based on, I think they said they found 40 tools, if I remember right. So it's a lot of property that can be
How big's that concrete saw? Isn't that, I mean, I don't think my trunk of my car could fit all this stuff.
I know I can fit a miter saw in the back of my sedan or in the back seat, but as far as each of these things, drills are easily movable. Reciprocating saws are, 2 feet long. A lot of this property could have been distributed at his house, at the house that the property, well, they said it was moved, but it also could have been at his construction locations. It could have been at his auto body shop. This isn't something that you have to move in one bulk product.
What about the fact that, as part of the minutes of testimony for Jones, he indicates that when they would steal the property, they'd steal it from a construction trailer, correct? And then they would take it over to McNeal's house. Then at McNeal's discretion, they would either put it in one of his construction trailers, or then they would take it over to this other property. Does that have any bearing on the probable cause determination?
That wasn't within the four corners of the search warrant application, so that wasn't something the magistrate, or I think was actually an associate judge, could consider at that point, because it wasn't within the four corners of the application.
What about the volume of the equipment? It may be that some of it was drills. A drill is obviously portable, but the estimate of value was $30,000 to $50,000 worth of stuff. That's more than a drill or two, obviously. What impact does that have on the analysis? And what about? And then I'll invite you to respond to the valuation point. There was testimony in the record about $16,000 as retail, and that they ordinarily bought new and so forth and so on. But there's also testimony in the record that lay testimony that the value of the tools was $30,000 to $50,000, well above the $10,000 threshold for theft.
And I believe that the $30,000 to $50,000 estimate was made by Jones in this case. Jones admitted that he had sold other property from other construction burglaries to other individuals. It's also important to note that part of the cooperation deal, Jones testified that the reason he was going around stealing all this stuff and selling it is because he had a methamphetamine addiction. So his valuation at $30,000 to $50,000, I don't think there's a lot of credibility in that. At trial, the owners of the equipment testified to the valuation. That's how we got to that aggregate number of $16,198.
That was only part of the equipment.
That's
Right.
what was recovered. That's what was recovered in the trailer.
Why should we discount the report from a citizen who's not accused or suspected of any crime, who's reporting on sort of some important pieces of the puzzle, a large trailer moved in a new kind of out-of-the-way location? Why discount that just because the citizen isn't talking about specifically about a crime?
I think, first of all, you have a possible issue of staleness when we remove the word recently from when the trailer was moved. We have a question of staleness on that. We also have an unknown tipster who the affiant described as an anonymous tip from a concerned citizen. So we run into the problems that a citizen informant normally observes a crime or is a witness to it, and that there's no recourse for the tipster. The tipster couldn't be held responsible if the allegations turned out to be fabricated. We don't know the tipster's motivation. This trailer was owned by R&C Construction. There are numerous, or R&C Auto, I believe. There are numerous employees there. The tipster could have very well been the person that moved the trailer or bought some of this and moved it. We don't know that.
But what difference does it really make? You know, whether that's true or not true. You get the anonymous tip, you go out and investigate the anonymous tip. If it's proven not to be a trailer owned by McNeal and or a business owned by him, then you don't use it. It doesn't form any basis of the case. So what difference does it really make?
Well, I think without the assertion of illegality,
Which we don't have here. We don't have any assertion of illegality here that we have to try to confirm.
it goes to the credibility of the tip and the reliability of it. Why do
we care?
Why is this anonymous tipster reporting to the police that this trailer was moved? What's the tipster's motivation for that? Why does he just randomly call the police and say, hey, this trailer was moved? I think there's concerns about the tipster's motivation and credibility. Your Honor, the search warrant was based on two anonymous sources that said that Jones and Way were committing burglaries. They made calls to David Downing about his construction business, and he was purchasing stolen equipment as well. Jones and Way were arrested for the burglaries, and Jones said that they'd sell the property, they'd offload at Cliff's daughter's house, and that he had moved because the police were there. The Court of Appeals correctly found that anonymous tip is not normally enough to establish probable cause. As JL, the U.S. Supreme Court said in JL, when a tipster doesn't explain the basis of knowing inside information about a concealed criminal activity, that is suspect. And as in Koima, the tip contained only publicly available information. Because the tip didn't contain it.
Don't you see a distinction between Koima and some of these other cases and this case, where I look at search warrants sort of as a continuum, and you look at the investigation that was performed by law enforcement. This is just one small piece of the whole probable cause determination, whereas in Koima and in a lot of these other cases, you're dealing with one specific piece of information, informant information. This is not Koima, and it's not these other cases, is it?
It's certainly not Koima where the sole reason for, in that case, for pulling over the vehicle. The tip wasn't the sole reason for searching the warrant here. But in Koima and in Walshire, the court wrote that the significant factors in those were that an informant was observing a crime in progress. In both those cases, we were dealing with drunk driving, so it was a serious public hazard. The intrusion on the privacy interests of the individual, a traffic stop in both those cases was flight. I believe in Koima, Justice Mansfield wrote that that's even less of an intrusion than a pat down. Here we have search of a trailer. And in those cases, it also indicated, as here, that it's important the tipster didn't provide his name. So in those cases, we're dealing with reasonable suspicion. Here we're dealing with the higher standard of probable cause. So while there is some other information in addition to the anonymous tip, we still have to reach that higher standard of probable cause. Your Honors, for those reasons, we respectfully request this court affirm the Court of Appeals and find that the anonymous tip was not sufficiently credible and that there's not probable cause to issue a search warrant for Mr. McNeal's trailer. Thank you.
Thank you as well, counsel. Ms. Triick, you may present your rebuttal argument.
While it's not directly applicable, I don't think, to the legal standards being applied here, I do think, because of several of the questions you asked my opposing counsel, I do want to point out that the police in this case did not overreach. They could have searched his house, they could have searched the secondary location, but they didn't think that's where the property was. So they continued their investigation until they discovered a place where they believed there was a fair probability and that they had some information that the property might be stored there before they executed their search warrant. I do want to take this opportunity also to speak briefly about error preservation. The defendant filed an original motion and an addendum to that motion, and that motion raised only 2 issues, one of which is totally inapplicable here and deals with the officers approaching the trailer to look at the VIN number and the license plate. And the other claim was that the issuing judge didn't comply with a portion of 808.3, which counsel said required the judge to make express credibility findings as to each and every confidential informant. 808.3 does not have such a requirement, and the defendant was not claiming in that motion that the confidential informant was not credible, but that the judge had failed to fulfill his statutory duty to make an express credibility finding. And that is not the same claim being raised on appeal. And so error as to that issue is not preserved by that motion and addendum, as the Court of Appeals found. The state believes it's important that officers are able to rely on carefully investigated and issued warrants in which a judicial authority has established that there's probable cause to believe that a search can be executed. We also believe it's important that officers are allowed to engage in the asking about of the community to discover publicly observable information. This is a common practice of law enforcement, and it's
Sure, but the issue is the 4 corners of the search warrant, is it not? I mean, our case law is pretty clear when evaluating whether or not there was probable cause. We look at the 4 corners of the search warrant, and that should be our focus here today, should it not?
It should, but in the 4 corners of this application, there is information from a citizen that was gained by law enforcement during their investigation. The citizen is unnamed, although we do not know that the citizen failed to offer his name, just that the name was not included in the warrant application. I think the warrant application actually suggests that Sergeant Bell knew the individual to whom he was speaking. And I think that that was a legitimate law enforcement technique, and they should have...
What if the citizen said he drives this trailer to work every day at 9 o'clock and he's always on Main Street? Does that give them a probable cause to issue a warrant to stop that vehicle as it's driving to work without any nexus that there's some stuff in there that's illegal?
Well, I think we have to ask if common sense would tell us when the defendant was moving his property to a place he believed more secure, to a secret place unknown by his accomplices that he believed more secure from police discovery because he knew the police were onto him, that the trailer he drives with him to work every day, would that be the place that common sense tells us he would store the property? While I certainly don't want to take a position for further cases, I mean, I think that at first glance, common sense might tell us that's not the place you would keep your property, that you knew the police were following you, you knew the police knew you had this equipment, that you probably store it somewhere more secret than the car you're driving around. But this particular situation, it wasn't the car the defendant was driving around. It was a trailer that he owned that was not easily discoverable that he owned it. It was parked on someone else's property. It was parked in a nondescript location. Even the informant and the officers didn't really have an address to associate with the location. So I think that common sense tells us a reasonable layman would believe that's where the property was being stored, or at least that there was a fair probability that that's where the property was being stored. Certainly a greater probability than his house or the location where we had been told he had already moved it away from. So unless there are further questions, for all those reasons, the state respectfully requests that this court reverse the holding of the Court of Appeals and affirm the conviction of the defendant for first-degree theft.
Thank you, Ms. Triick. The case then is now submitted, and just for the students' information, if you're interested in following this case, a decision, a written opinion will be filed probably sometime in June, if perhaps a little before, but and you can go online and follow that if you want at iowacourts.gov. Thank you again for being here. We'll be in recess until our fire drill is completed.